The trial chamber is back in session. Let's move into a closed session for a few moments, Mr. Registrar, or private session.
Now an open session. Bien. Alors,
Thank you. Chapter 2. 98 bis proceedings, acquittal. I'm not going to revisit some important parts that have been mentioned, addressed in the majority decision, but I must remind you that pursuant to the former wording as amended, before it was amended on the 17th November 1999, an accused may file a motion for acquittal on one or several of the offences in the indictment within 7 days following the close of the prosecution case, and in any rate before the beginning of the defense case, further to Rule 85A to little I. B. If the trial chamber is of the opinion that the evidence adduced is not enough to sustain a conviction for this or these charges, it enters a judgment of acquittal at the request of the accused or propria motu. The way this former wording was used by trial chambers has given rise to very long, very lengthy written decisions, sometimes with dissenting opinions, and the filings with the appeals chamber. It was a time-consuming procedure, and it was likely to delay the proceedings. Therefore, a reform was introduced in 2004 under the incentive of the president of the tribunal. It aimed at speeding up the procedure by turning the procedure from a written to an oral procedure. And the text, the wording as adopted is as follows. At the close of the prosecution case, the trial chamber must shall, by oral decision after hearing the oral submissions of the parties, enter a judgment of acquittal on any count if there is no evidence capable of supporting a conviction. The 90 bis proceedings, because of the amendment of this rule in 2004, does not make it possible, because it is an oral decision, because it is an oral opinion, does it make it possible to really go into details with very specific and exact references, as was done before with written decisions. As it is forensically impossible to go into further detail, I cannot review each and every crime to try and identify its possible perpetrator. At this stage, I can only conclude that the author is alleged to be part of the Serb forces without any further specifications. The Serb forces are collectively defined as members of regular units of local TO, often from local TOs, from members of paramilitary paramilitaries, Arkensmen, Yellow Wasp, White Bees, Šešelj Band, or other volunteers, without specifying whether these are volunteers affiliated to a political party, like to the Serbian Radical Party. The majority opinion is that it is not possible to enter a judgment of partial acquittal based on the wording of this rule. I disagree totally with their interpretation. All the more so since I'm the co-author, together with another judge, of the very wording of the new rule. The purpose of this reform was never to make it impossible to enter a decision of partial acquittal. It would have been paradoxical that the very purpose of this reform, which is to gain time actually would have reached the opposite result, on the very ground that it is not possible to enter a decision of partial acquittal. It would be equally paradoxical to force the accused to adduce evidence whilst, for specific counts or parts of counts, the prosecutor did not lead any evidence, or because the evidence they have adduced is not sufficient. This being so, unlike the majority opinion, I am of the view that it was possible for the trial chamber to make a decision of acquittal, in part or total. Furthermore, the English and French versions are authoritative. In French, the fact that you use the term of chef d'accusation, count, instead of infraction, offense, semantically boils down to one and the same thing, because a crime is an element of an offense, an ingredient of an offense or an account. The fact that later on, after this amendment was made, there was no partial acquittal does not mean that this was impossible. It's just that the trial chambers did not look into the matter or did not want to. The Rule 98 bis proceedings, because it takes place at the close of the defense case and before of the prosecution case, and before the defense case, is very similar to the no case to answer motions of the common law type, when there's a motion for acquittal for insufficient prosecution evidence, and the defense does not respond to that, does not reply. Although the fundamental concept behind Rule 98 bis has been borrowed from common law, this rule has to be read in its own context, in the light of the statute and the rules. Therefore, there may be discrepancies between the way the tribunal applies it and the way it is applied in common law systems, in common law jurisdictions. For instance, as to the notion of the legal test to grant a motion further to Rule 98 bis.
The trial chamber judge, as mentioned by the appeals chamber jurisprudence, since their appeals judgment in case the prosecutor against Jilicic, must assess whether the judge would enter a conviction beyond any reasonable doubt, given the evidence adduced by the prosecution. This is what the trial chamber said, and I will quote. The prosecution submits that when the trial chamber required the guilt to be established beyond any reasonable doubt after the presentation of its case, it applied a criteria different and stricter than the one required by law. In its point of view, what should have been done is to check whether the evidence, once admitted, had allowed a reasonable tribunal to decide whether the accused is guilty. The question is not to know whether, given the evidence adduced, that the accused should be found guilty, but whether he could be found guilty. The jurisprudence of this tribunal regarding the implementation of Rule 98 bis of the rules has constantly indicated that judges must enter an acquittal if the evidence adduced by the prosecution would not allow any reasonable judge, beyond any reasonable doubt, to find the accused guilty. Why is it that in common law there was this need to qualify the judge as reasonable? By definition, a judge should not be unreasonable, and the judge should not be incompetent, nor should he be unbiased. However, in common law, these terms were found reasonable judge. Similarly, why is there this addition of beyond any reasonable doubt? Beyond any reasonable doubt is the criteria that is required for evidence in an adversarial criminal trial, which means that the evidence adduced by the prosecution must prove, inasmuch as there can be no doubt in the mind of a reasonable judge, that the accused is indeed guilty. Now, this notion of a reasonable judge refers to a legal fiction. It is a standard used to measure the behavior of an individual. This standard is used in common law, in tort law, notably, to determine whether there has been a violation of the duty of care. Here, this duty of care is similar to the notion of bon père de famille in French. This is a very abstract individual seen as the behavioral standard used to measure the behavior of a given person in order to determine whether a offense has been committed or whether there, and to what extent. This notion of reasonable judge, therefore, refers to a yardstick used to measure how the judge can appreciate a reasonable doubt. Now, the content of this notion of reasonable doubt in a criminal trial is, because of the bias it induces, very uncertain. This notion in the United States is seen as a fundamental guarantee for the rights of the accused, whereas in England it has been abandoned or quasi-abandoned in criminal cases. In principle, whenever a judge has a doubt, the accused must be given the benefit of this doubt. So the terms beyond any reasonable doubt create, according to me, a greater standard. It seems to me that the judge must be convinced without a single hesitation that the accused could be found guilty after the evidence has been analyzed. Therefore, the case law of this tribunal is extremely strict. The point here is not to examine the evidence prima facie, but to examine the substance of things with everything that should be used to appreciate the elements, the evidence. In a word, we're not here just to note facts or to say that facts have happened. We have to explain why and what are the probative evidence adduced by the prosecution which could allow a reasonable judge to enter a conviction. Similarly, to make its decision, the trial chamber must determine whether for each elements of the crime, there are elements which, at their highest value, could possibly satisfy this trial chamber between any reasonable doubt that the accused is indeed guilty. The trial chambers, on several occasions, had the opportunity to rule on these type of motions and to enter judgments of partial acquittals. In other cases, the trial chambers just dismissed these motions. As far as partial acquittal is concerned, I could quote the decision of April 6, 2000 in the Koydic and Cherkes case. The decision of February 28, 2002 in the Martinovic-Neletilic case, the decision of November 28, 2003 in the Bridginen case, the decision of June 16, 2004 in the Slobodan Milosevic case, and the decision of September 27, 2004 in the Hadzi, Hazanovic and Kubura case. Partial acquittal is possible in law because it corresponds to the spirit and the letter of Rule 98 bis. Why should an accused, while presenting his case, call witnesses in order to rebut number of elements supporting an offense? For example, in the Slobodan Milosevic case, the trial chamber entered a series of acquittals on the Bosnia-Herzegovina's part of the case, noting that on the one hand there was no evidence adduced for some paragraphs, and that on the other hand that the evidence adduced was insufficient. In a recent decision in Milutinovic and al., which was issued after the 2008 reform, the trial chamber in its oral decision stated, and I quote, "Where there is no evidence to sustain a count, the motion will be granted. Where there is some evidence, but it is such that, taken at its highest, the trial chamber could not convict on it, the motion will also be granted. Where there is some evidence, but it is such that its strength or weakness depends upon the view taken on the witness's credibility and on one possible view of the facts the trial chamber could convict on it, the motion will not be granted." End of quote. Similarly, the Milutinovic chamber referred to the legal test used in the Yelisic appeals judgment and to the 98 bis decisions issued in the following cases: Slobodan Milosevic, Mrksic, Martic, and Dragomir Milosevic. The purpose of Article 98 bis is extremely clear. It is meant to prevent trial from continuing in cases where prosecution did not sufficiently provide proof of its allegations, and in the absence of any analysis of the position of the defense through its evidence either mentioned, already produced, or to be adduced. Furthermore, since this is a very long case, we know that the accused has been in provisional custody for more than 8 years. I believe, therefore, that the standard of review for the evidence in Article 98 bis should be higher than in ordinary cases where there is an expeditiousness, according to the statute of the Tribunal. It would be unfair to continue a trial when the evidence adduced so far are insufficient. Note, especially since the provisional detention has been extremely long, and that prosecution has had all its time to put the finishing touches to its investigation. Since we know that here at the ICTY, the prosecution during the trial can continue its investigation and can adduce, whenever it wishes to do so, new evidence, sometimes at the very last minute, as was the case with the diaries of General Mladic. I will now turn to the crimes alleged in the indictment, crimes committed in Croatia, Bosnia-Herzegovina, and Serbia. As far as the crimes alleged in the indictment are concerned, I believe that some of them have been established through the evidence adduced by the prosecution, but some others have not been established. In the annex that we will soon have on the screen, you will see the evidence which, according to me, could allow any reasonable trier of fact to conclude that there was a crime, as the statute of the tribunal understands it. For crimes committed in municipalities, I will recall for each and every one of them what evidence has been adduced by the prosecution in its preliminary brief as well as its oral submissions. I am not going to recall the position of the accused because it has been given in detail when reading the majority decision in the trial chamber in its first chapter, review of the procedure. However, I must remind you of the position of the prosecution in a detailed way by quoting all witnesses and documents supporting its allegations regarding the crimes, which is what I'm going to do for crimes committed in Croatia, Bosnia-Herzegovina, and Serbia. Given that there are a lot of references, I will ask to be placed on the screen a summary chart of all the evidence adduced by the prosecution. Before this, however, there are other elements I must deal with.
L'examen attentif des éléments de preuve admis.
The careful review of the elements of the evidence adduced and the testimonies heard by the trial chamber during the prosecution stage could lead a reasonable judge to conclude that beyond any doubt that the crimes alleged in the indictment were actually committed, and this undisputedly, except for some points which I will detail later on. It is thus possible to conclude that within the time period of the indictment, from August 93 to September 93, military actions were carried out in a number of towns of former Yugoslavia, notably in Croatia, Bosnia-Herzegovina, and in Serbia. Mainly in the cities of Zvornik, Vukovar, Mostar, Nevesinje, and Biljana, in the framework of which civilians or enemy fighters were captured, some were detained, others were mistreated, and a large number of them were executed. The list of the victims mentioned to illustrate these crimes can be found in Appendix 3, 4, 5, 7, 9, 10, and 11 of the indictment. This being said, regarding counts 12 and 13, wanton destruction of private or public property, does the prosecution give enough evidence to prove that the crimes committed during the period mentioned in paragraph 34 of the indictment and in the cities mentioned in the indictments were actually carried out by groups on the terrain and which came under the authority either of the JNA or of the VRS? Military authority. Therefore, regarding the destruction of buildings, it is true that some of them were damaged or totally destroyed, but the report of the prosecution expert, Mr. Andreas Riedelmeier, is not such that that these destruction could be directly attributed to a single group and does not allow also to provide exact dates for this destruction. It seems that the expert used documents drafted after the events and on photographs taken before, during, or after the events. Therefore, how is it possible to say that in a given locality, in a given city, a mosque which has been completely destroyed is a parking lot now. But the mosque might have been destroyed by the municipality after the events for different reasons. Maybe just because this mosque was about to crumble. The expert did not answer these kinds of concerns. And if I do have elements and evidence that allow me to conclude that these buildings were actually either damaged or destroyed, but I don't have enough evidence to attribute this damage or destruction to a specific group, which would have acted under the direct authority of the accused as alleged in paragraph 34 of the indictment, under any modes of liability, including JCE 3. I would also like to add that as far as Mostar is concerned, all these buildings might have been destroyed during the conflict between the Serbs and the Muslims and the Croats, or also during the conflict between the Muslims and the Croats, which introduces another element of doubt. Regarding the counts 12 and 13, dealing with the wanton destruction of private and public property, as things stand now, the following religious buildings must be excluded. In Mostar, the Nezu Aga Mosque, the Nezu Aga Vukšaković Mosque, the San Franciscus Monastery, and the Most Sacred Heart of Jesus. In Nevesinje, the Islamic Clock Tower, the Haji Dervish Čukač Mosque, the Market Mosque, and the Sinan Dede Efendi Mosque. Regarding the municipality of Zvornik, the Mekted, and the Gushteri Mosque, the new Donje Križevići Mosque, the Zdravke Mosque, and the Vitinica Mosque. In the area of Sarajevo, the Haji Idris Mosque, in Hrsno, and the Catholic Church of the Holy Trinity in Novo Sarajevo. Because the only buildings that should be taken into account are those who have been extremely damaged. You'll see later on the chart, they will be noted LDE, or the buildings that have been partially destroyed, marked with PD, or the buildings that have been totally destroyed, CD. However, contrary to the crimes of plunder, which I will expound on later, even as things stand now, there are some failings, as described above. The trial chamber, when it deliberates, will have the expert report, as well as other documents, which may lead it to conclude in a very specific fashion that such and such building has been destroyed, and this at a specific date with the specific identification of the perpetrators. And thus, a reasonable trier of fact could conclude that, as things stand, these destructions did occur. Regarding count 14, plunder, at paragraph 34 of the indictment, the prosecution says that public and private properties were plundered in the municipalities of Zvornik, in Greater Sarajevo, Mostar, and Nevesinje. I believe it is necessary, regarding this plunder, to have at least a few intangible evidence, such as the list of the victims of this plunder, an accurate description of the goods plundered, the photographs or reports on these goods, and the elements helping to identify the perpetrators. But I must note that, unfortunately, this evidence does not exist as things stand. Therefore, I cannot conclude that hundreds of houses were plundered in Vukovar, Zvornik, in the greater Sarajevo region, in Vogosha, in Mostar, and in Nevisinje. Consequently, I'm now going to show on the screen the charts which include the evidence which, according to me, could lead a reasonable judge to conclude that the alleged crimes were actually committed. I will ask the court officer to place the summary chart of the evidence under the Elmo. Here you have a list of all municipalities. On the left-hand column, exhibits, you have the list of the documents which, according to the prosecution, are evidence of the crime. And on the other column, witnesses, you have the number of all the witnesses who testified about these crimes. This is a summary chart giving you the position of the prosecution. I will now get into the details, and I will ask the usher to show us Annex 1, which deals with Vukovar.
Dans cette annexe, il y a
In this appendix, on the left-hand side, you have the paragraphs in the indictment. Second column is paragraphs in the pretrial brief. Footnotes in the pretrial brief, which refer, of course, to these paragraphs. And on the right-hand side column, list of the witnesses and documents which, according to me, can prove that crimes were actually committed in Vukovar. For paragraph 16, for example, Whitman VS 011 and VS 015. I will later hand to Mr. Marcus and Mr. Šešelj these charts. Therefore, they can take a look at them. And believe me, this took hours to put together. Appendix number 2, Voshin. Same principle. You have paragraphs in the indictment, paragraphs in the pretrial brief, footnotes, and witnesses and documents supporting the allegations of the prosecution. Then Annex 3, Bielina. Oh, I'm not going to go through all of these annexes, otherwise we'd be spending weeks here. So for Bielina, you have the paragraphs in the indictment mentioning Bielina, paragraphs in the pretrial brief, footnotes, and witnesses and documents. Then Berchko. Same thing for Berchko, paragraph in the indictment, pretrial brief, footnotes, witnesses and documents. For Bertko, you can see that this is not supported by many witnesses, only mainly by witness VS 1033. Appendix 5, Bosanski-Samic. Here again, same columns. Paragraphs in the indictment, paragraphs in the pretrial brief, footnotes in the pretrial brief, witnesses and documents, and you can note that here again we have an interview of Mr. Šešelj mentioned to support paragraph 16 of the indictment, paragraph 86 in the pretrial brief. Zvornik